Let's bring in our guest. Okiya Omtatah, activist, good morning and thank you very much for joining us this morning.
Morning.
Welcome to the Situation Room, Okiya.
Thank you.
So, first, give us the background of this particular case that you had taken to court, that you got a ruling in your favor yesterday with regards to the chief administrative secretaries, and then you'll tell us about the cabinet secretaries.
Basically, when His Excellency Uhuru Muigai Kenyatta, the President of the Republic of Kenya, was given a fresh mandate, he constituted a new government, and the manner in which he did it did not, I found it not to accord with the law. And so I decided to challenge it in court. And among the issues I was not happy with, one was that he carried over cabinet secretaries from his first term. Yet that term had been terminated when he went for elections and he took a new oath of office.
Mm-hmm.
Now, I didn't see the mechanism in law for transiting a cabinet secretary from one administration to another.
Mm-hmm.
And the purpose of vetting is not cosmetic; it's an appraisal. So, if this guy had been given an opportunity to serve for 5 years, then he should be appraised after the 5 years before he's given a new mandate.
Yes.
It happens even in boards where somebody is re-elected, where somebody's term is given a fresh term. So they may not go into the nominating and whatever, but the board sits and appraises the CEO and says this person is fit to continue serving.
Yeah.
So you cannot have somebody in office for 10 years without an appraisal.
Mm.
And the appraisal is by the parliament. Number two, being a political environment, it is also possible that some fellows can gain a lot of weight and be able to intimidate the president to keep them in office. Whatever. So, a parliament that is not beholden to those kind of pressures, and the parliament can decide if the fellow is not a performer, can jack him off.
Mm.
Number two, some principal secretaries were appointed without being recommended by the Public Service Commission. And the Constitution is very clear that at that level, the Public Service Commission recruits, and the President presents the names to Parliament, and the Parliament approves that an appointment is done.
Mm-hmm.
That was not done. Then the biggest violation of the law was the office of the Chief Administrative Secretary. Much as this office was being created, you get a letter from the President on 23rd asking for the office to be created. On 24th, the Public Service Commission writes back saying that it has approved the request by the President.
Mm-hmm.
Now, when you look at Article 10, how does a public body approve a policy?
Mm.
It has to be public participation. If it's going to have an impact on the budget of the national executive, the Salary and Remuneration Commission must come in and have a say. Mm-hmm. So all those things were overlooked. So much as the president has been given the capacity to create office, and I think the president in this particular case did his part by asking for concurrence from the Public Service Commission. Mm. But the problem of packing these commissions with the loyalists and the bootlickers and hanger-on is what you are now saying, that the commission, when they received the letter of the president, they didn't even read it. They just wrote back and said, do as you wish. Mm. So that was the challenge. So it's also a problem of the independence of the commission.
Sure. Okay, if
the Public Service Commission had done its work and then the thing had been approved constitutionally, at least one limb of the issue would not have been a problem. Then the second now problem comes, these are in a constitutionally created office, then the way it is filled is announced in the public service, it must go through recruitment, competitive recruitment. Mm. It's not one of those appointments the president makes in the executive whereby using his discretion, he picks somebody and then those persons are taken to parliament for vetting. In this particular case, Somebody goes through a recruitment process, an interrogative process. He sits interviews, he's appraised, then he's found suitable to serve. That did not happen in the names of these people. So the CIS were put into office illegally, and even the office was created illegally.
Okay.
That's why it has been abolished.
All right. So now taking this to court, taking this forward, what was the goal? To have,
Pardon?
what was the goal? To have everybody have the country see the illegality of this establishment of these offices and the continuation of the term? Was it for people to see the unconstitutionalism of all of this? What was the reason or the factors now contributing towards taking this to court?
Well, taking to court was to uphold the rule of law because we have got a system of checks and balances. And among the checks and balances is the judiciary. The judiciary plays a supervisory role over this other organ. So where you feel that, and the judiciary is the custodian of the Constitution, so where a person or a citizen or a member of the public feels that the law has been violated, you don't look for militias to begin eliminating these people, assassinating them. You go to the judiciary and say, I think the law has been violated. What do you determine? What can the court say about it? And the court looks into it and makes an expression, which that's what has happened. And I think this particular ruling that Justice Murima gave was very, very detailed. He went beyond what I expected in terms of analysis. Some things he disagreed with me, and I've agreed that I was wrong. Like on the issue of the creation of the position of the issue of the creation of the office of the Chief Administrative Secretary. He says it can be created constitutionally. It's not constitutionally by design or by principle. It's not constitutional in the way it was created by the President and the Judicial Service and the Public Service Commission. Can create that kind of office.
Okay.
But they must subject it to public participation and other procedures that are required for. So Justice Murima did an excellent job, and he clarified the law. And I hope that those who are in charge of government should take this opportunity, because basically the judge has dissolved the President Uhuru's cabinet. The judge has dissolved it. When you fire almost half the cabinet, then the cabinet is basically dissolved. So when President Uhuru should seize the opportunity, we've even been hearing things saying that they want to reshuffle the government, they want to do whatever. It's an opportune time for the president to reconstitute his government using the law. Another thing is advisors. A lot of issues I take to court would not happen if the president had people who are properly anchored in law. I think a bunch of those people, I would say, is being advised by a bunch of monkeys who are after bananas, and he's not able to get proper advice in terms of what he needs to do to accord with the Constitution in whatever he's doing.
If we look at,
so I think there's a problem with these advisors.
If we look at for example, this position of the Chief Administrative Secretary and the judge's ruling, the way you've explained it, so it is there's nothing illegal about the president seeking concurrence of the Public Service Commission and creating this office. It is now the procedure after that where the fault was found. That the Public Service Commission, there should have been more public participation and all.
The president did his part correctly.
Okay.
He wrote a letter to the Public Service Commission requesting that he be allowed to establish this office. And I think under Article 132, the president has got the power to do that.
Okay.
He's allowed to do that. But now what happens is that the Judicial Service Commission failed in mandate in advising the president, because it should have subjected that process and maybe come up with a conclusion that the office is not acceptable because of the cost it's going to create. The Salaries and Remuneration Commission maybe have come and said the cost of this office is going to be too high. The public would have said, no, we don't want the office and whatever, and maybe then the president could not be able to go ahead. Then they would advise the president and tell him it is not viable to create this office.
Okay.
But when they just did a knee-jerk reaction to the president's letter and locked out the Kenyan public and the other institutions which are supposed to input in that request to show that either the request is viable or is not viable, then that process becomes unconstitutional and therefore null and void.
Quite interesting. This let's take a break at this point, Okiya Omtatah, and then come back and look at what remedial steps can the president take on all this? The principal secretaries, the chief administrative secretaries, and the cabinet secretaries. What did the court order to happen, and what is it that the president can do? The High Court judge ruled that the office of chief administrative secretary was not properly created. And we are speaking with the activist Okiya Omtatah, who took this matter to court, and he says yes. So this is what the judge said. Said the president is allowed to create a new office through the Public Service Commission. The president wrote to the Public Service Commission saying, I'd like to create a new office, and this would be the office. The Public Service Commission responded to the president and said, it's okay, go ahead, create the office. Now, what the court finds fault is the procedure followed by the Public Service Commission in establishment of this office of Chief Administrative Secretary. There should have been some more public participation. There should have been some consultation, for example, with other commissions, like the Salaries and Remuneration Commission. Maybe the public should have had an input. And also, if then it becomes an office in the public service, how do you recruit somebody into the public service? There's a competitive process of recruitment. All these things were not followed. So judge says, therefore, here we find fault. But then there's also the issue of CSs and the PSs, and who were not freshly vetted, in the CSs who were not freshly vetted from the previous term, and some PSs who were not appointed through the proper channel. Okiya Omtatah, just explain again the appointment of the principal secretaries that was not done properly.
In the Constitution. And what I was aggrieved by is the manner in which these people were appointed. They did not follow the process that was required. So you require a clear recommendation from the Public Service Commission saying that ABCD qualifies for appointment, and then the president presents their names to Parliament, and the Parliament approves or rejects them. So that did not happen in our particular case, and so that appointment is basically unconstitutional because it's violating a clear procedure that's laid out in the Constitution, and so it becomes a nullity. So these jobs have to be re-advertised, and people should be given a chance to apply, then be interviewed, then be shortlisted, be interviewed, with public participation, and then those who succeed given to the president for nomination to the National Assembly for appointment. And this elaborate procedure is put into place to ensure that Kenya gets the best that it has. Yeah. So that the idea of jobs for boys is no longer there. Under the old constitution, I think it's section 23, 24, 25, it vested the power to create and make appointments in the president, and the people served at the pleasure of the president.
Yep.
But today, the power is given to the people through the Public Service Commission to do that, and they are protected by Article 236. Article 236. That they cannot be sacked by the president if there's no reason why they should be sacked. If somebody is performing his work well, assuming, and I'm not saying he does it, assuming that the president wanted somebody to do something illegal, and the person refuses. Today you cannot be fired. But in the old system, the president could simply take a phone and say you are gone, and you are gone. So that's what is happening. So Article 155 of the Constitution is very clear that the president shall nominate a person for appointment as principal secretary from among persons recommended by the Public Service Commission.
Wow.
And with the approval of the National Assembly, appoint principal secretary. If that is not done, the Constitution has been violated and such a person cannot hold office.
Okay. Now, Omtatah, what does this mean today? From this ruling that has been given yesterday, I mean, you very clearly said, I mean, from where you're coming from, that these individuals then don't hold office according to this ruling. They've been fired.
Yeah, they've been fired.
Okay. Now, according to the ruling, though, is that the Attorney General has been given 30 days to produce a report detailing the position of the CASs and the Cabinet Secretaries in terms of gender and regional balance. So what does this mean then? He's been given 30 days to basically tell us the status of things, take things back to the office of the executive, or how exactly does this work for Kenyans to now understand what happens with these positions?
There was one limb of the petition that was not determined, and that was the gender composition of the cabinet and the principal secretaries. And that's why they want that because the judge said this matter was filed in 2018, there have been changes. So the judge wants to know from the Attorney General what is the current composition in terms of ethnicity and in terms of gender, so that you cannot make the final conclusion as regards to whether the composition of the cabinet as it is today is also unconstitutional based on those two considerations.
Okay.
Yeah.
So what happens today, Omtatah? That's the question. Are these fellows showing up for work at 8 o'clock today? You know, kind of thing. This is what we're looking at today.
Well, from my understanding, is that the chief administrative secretary ceased to hold office yesterday and they were sent home. In terms of the cabinet secretaries and principal secretaries, the judge seems to have given some window for them to continue in office during the peak of the pandemic. And he said as soon as the curve flattened, when the government announced that the curve has been flattened, the registrar will have the matter mentioned before the judge to confirm compliance with that. So the president has been given some leeway during the peak not to comply with the finding of unconstitutionality in terms of cabinet secretaries and the principal secretaries. But the chief administrative secretaries have been fired. They are gone.
Now, if we say that the court has found that you have been holding this office illegally and unconstitutionally, what does it mean retroactively? Does it mean that any work that you had done, any decision that you had made, any salary that you had earned?
No. In terms of the salary, addressed the issue, and the judge clarified that since it's the president who appointed, any order regarding salaries, refund, and distributed work would require also the president to be subject to that order. And the president cannot be ordered. He enjoys immunity under the law. So that the order would not be preserved. In terms of the work they have done, assuming they signed a contract committing Kenyans to a third party, those contracts are valid. There's something in law which is called the doctrine of the odious officer. The doctrine of the odious officer simply says that somebody occupying an office, a public office, and acting in good faith can make decisions that are binding. And so that doctrine, I think, if it is invoked, will save the work those people did.
You know, when I look at this, when you look at this, the case that you took, Omtatah, you're basically questioning and challenging those in power to follow due process. Those who hold an office that should follow due process in advising the president, in interpreting the law, in making such appointments, to follow due process. And you've raised this a number of times, even during this interview, that At some point, the president acted on the advice that he received from his advisors.
Yeah.
He was advised we need to follow the process of alerting the the Public Service Commission. The PSC responded. Now, where is the breakdown here in terms of is it that the people who are advising the president are not giving him sufficient advice, and why would they be doing that? What would lead us to have so many cases in court over such matters of procedure that are clearly stipulated in law?
It is. I find that the president is really exposed. From where I sit, I think the President Uhuru is really exposed because he has surrounded himself with monkeys, which are just after bananas. Not people who are out to help him run this country according to the law. And so I think that he needs to revisit. He used the word revisit. He needs to revisit his college of advisors and ask them some hard questions. As regards the Public Service Commission, it owes Kenyans an explanation why it did not follow the procedure after the president submitted himself to it. Why did it go to the president? But also the problem is that most of these commissions have been packed with hangers-on, loyalists, bootlickers. So the commissions that do not have the teeth the Constitution expects them to have. They were created almost as a fourth arm of government, speak truth to power. So if the power has been given to the commission and it cannot exercise it, I think a consequence of this should be that the entire commission should resign.
Well, Omtatah, I like what I'm hearing from you and the thoroughness with which you've approached this matter. Now, I want to ask a legal question. Does our law and does our president, no, let me ask, does the president have any powers to appoint anyone whatsoever without going through the Judicial Service Commission, the Public Service Commission or Parliament?
The president does not have those powers, except if he invokes Article 58,
Yes.
state of emergency. If he invokes Article 58, and I think he has it only for 14 days, he can exercise power by executive fiat. Otherwise, he must follow the procedures laid down in the Constitution, and even under Article 58, there are only limited times when the president can exercise that power. Is that if the state is threatened by war, invasion, general insurrection, disorder, natural disaster, or other things, he can order like resources to be mobilized without going through Parliament to approve a budget. Let's assume that a major disaster hits a part of the country. So, and then by then he has to go back to Parliament after doing that to have the emergency sustained after 14 days. I think he can only do that for no longer than 14 days. Then he's go to Parliament, and then Parliament can now legislate and give him the legal framework within which to operate.
Okay, now
So outside that, he must follow the law.
You've removed a little darkness from where I sit, but then now I get confused. So what role do executive orders play, and what really are these executive orders? Because every time something happens, I hear it's an executive order, and I'm wondering, okay, so this man can still
The executive orders themselves are a tool or are a policy tool, and they are subject to Article 10, which requires public participation and all those kind of things. So an executive order just given a roadside declaration cannot stand. If you remember, there was this issue whereby a declaration was made that all accounting officers, procurement officers have to go home when
it was procurement officers, yes.
Yeah, I challenged that matter in court, and the court found it to be that order to be illegal, and they quashed it. Because of various factors. Yeah. So the executive fiat is not allowed, but the Constitution gives the president a lot of powers. If you just follow the procedure, he's a very powerful individual. There's nothing he cannot do. All that he has to do it in a certain way. It has to be lawful. It has to be procedural.
So would you argue then that the vestiges of the previous constitution and the previous powers that previous presidents enjoyed is still lingering? Because it's like one still goes through the process of doing things the way they were done. But it's not only with those in the executive office or the head of the executive, but also the citizen. It's like you still expect that your president has the same powers that a previous president had.
He has the powers. The only thing that he does not serve himself. He serves the people. He's an employee of the people. So at the end of the day, that whatever he does must be for the good of the citizen, not for his own good. You see? Mm-hmm. And you can see the difference there. The old president did a lot of things for his own good. The executive power was vested in him. Under this constitution, the people are sovereign. The president is an employee of the people. And whatever he does, he must be doing that to serve the people. And when he is out really to do something for the good of the people, nothing limits his power. But if he tries to do something that's against the people, then his power is totally limited. That's the clarification I would make.
Thank you.
Thank you very much, Okiya. Thank you very much for joining us this morning and also for clarifying in this particular case. I mean, it's the way, just to look at it, it's a landmark ruling because it sets the precedent. It says, this is the procedure. You shall always follow procedure. Asante sana, Okiya, even for taking the matter to court on behalf of Kenyans.
Thank you very much for the opportunity.
Yeah.
God bless you. And I also wish to take the opportunity to thank the Law Society of Kenya, to thank the Katiba Institute, to thank the Kenya Human Rights Commission, who came in and supported the petition.
Asante sana. Keep it right here. The conversations continue. This is Kenya's biggest conversation, the Situation Room. We are in Nairobi, Mombasa, Kisumu, Nakuru, Eldoret, Nyeri, Malindi on Spice FM. We are also countrywide on KTN. We are also global online.